Thank you for joining this episode of our webinar series on best practices in eDiscovery. Today's session is focused on best practices negotiating a state-of-the-art ESI protocol. My name is Jeff Fugit. I'm Vice President of Sales and Marketing for Lexby, and I'll be the moderator for today's event. Our webinars take place monthly and cover a variety of relevant eDiscovery topics, trends, best practices, and strategies. Space is limited to the capacity of our webinar platform, and with the popularity of these sessions, I recommend registering promptly for those that are of interest to you. If you have technical issues or questions, please email us at webinars@lexby.com and we'll address those right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. A little bit about us. We're based in Austin, Texas. We provide a very affordable cloud-based eDiscovery platform and services. We specialize in equipping the boutique firm with an eDiscovery solution that gives them full control over the eDiscovery process, DIY capabilities, and incredibly fast performance. We're the industry's most affordable, full-featured DIY eDiscovery platform. We're the industry's fastest eDiscovery processing and document review platform. We deliver the industry's fastest return on investment, and that was confirmed by a survey that was done late last year by G2 Crowd. We've got an experienced staff of eDiscovery specialists and expert consultants who are all ACED certified. And if you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled for you. Today's topic is fascinating given the growing and shifting ESI landscape and the proliferation of communication channels. As you can see on this slide, from Slack, mobile messaging apps, as well as the growth in the number of email accounts per custodian, all of this exponentially increases the challenge of making sure the ESI agreement covers what you need for the matter. It is also important to stay abreast of emerging ESI sources like intelligent virtual assistants with Amazon Alexa, Apple Siri, or Google Assistant, increasingly being identified as sources of evidentiary ESI. Luckily, we have with us today Gene Albert, who will walk you through the best practices and critical steps to ensure your ESI agreement will deliver on your needs. Gene is the CEO of Lexby. He is a frequent speaker and author on eDiscovery and legal technology topics. He's on the Planning Committee, Electronic Discovery Institute, State Bar of Texas, and he is an eDiscovery consultant and expert. Gene has a BA and MBA from the University of Texas and a JD from SMU. Before I turn it over to Gene, I want to ask for your participation in some polling questions to help set the stage for today's presentation. And our first polling question is, how confident are you that your current ESI agreements are helping you win matters? 100% confident, pretty confident, somewhat confident, not very confident. Okay, I'll go ahead and close out that polling question. And our next question is, what percentage of your matters do you consider document intensive? And while you're answering that, I'll take this time to thank you for participating in our polling questions today. All right, a couple more answers are coming in. All right, I'll go ahead and close that out. And without further ado, I'll turn it over to Gene Albert. Gene?
I'm Gene Albert, CEO of Lexby, and welcome to our webinar today of negotiating a state-of-the-art eDiscovery protocol. This is an important area, and we've received a lot of requests to update our webinar, and we haven't done this in a couple years, so that's what we're doing here. And I think there's been a lot of developments having to do with different types of data types and how the courts are treating these that makes this pretty timely. At the end of the webinar, we'll have a brief survey that just takes a couple minutes, and if you have time to stay around and fill that out, please do. We look at those real closely, and any suggestions you have for how we're doing these webinars or content you'd like to see in the future, we'd welcome them. But let's get started. We're going to cover today why negotiate an ESI protocol, what are the legal requirements, and different negotiation points that are important. And we'll finish up with how to get a sample, one that we've developed here at Lexby for our clients or others who are interested, and how you can get it. First question is, what is an ESI protocol? ESI stands, of course, for electronically stored information, and it is a court order, could be agreed, stipulated order, or it could be entered in a contentious proceeding, or it could be a separate agreement. And it sets out the expectations of what's going to happen with the subject matters of the protocol. There are reasons for doing it different ways, to the extent that it is done without a court or magistrate participation. It can be done just as an agreement between the parties. That's more informal. It doesn't require a hearing, but doesn't probably bind anybody other than the parties to the agreement. And there may be more difficult to get it enforced later, or possibly. If it's done with a court's agreed order, then it's more central in the proceedings of the case, and then also it possibly is going to bind others in the matter other than the parties who signed it. Number of reasons why to negotiate an ESI protocol in cases that have a good amount of electronically stored information. First is just the massive proliferation in the workplace of different types of ESI in cases, and it just continues to grow. It's challenging, if not scary, to competently deal with all the issues that can come up in preservation, collection, review, and production in a lawsuit. This can include, the many different types of devices that custodians can have, including their computers, workstations, shared drives, cloud storage, smartphones, tablets, media accounts, goes on and on. And the other type of data repositories that we can see in Workspace, and then just the different types of information that can be included in there, including not only just email, but instant messages and text and text messages and database structured data. And this is all where the evidence of a modern commercial suit lives. Another reason is it's a natural outcome of the required Rule 26 conference under the federal rules. And as a side note, in this webinar, I'll be speaking in terms of the federal rules as we offer these across the country, but there generally is going to be something similar in the state rules of most states now. Another point is that having an ESI order is often required in certain courts, and they may have their own standing orders that will be a starting point of an ESI order, but then those can be added to and negotiated. Judges and magistrates are increasingly knowledgeable of these sort of protocols and would expect it of parties in a complex litigation. These can reduce confusion and ensure consistent deliverables. And this is going to, in the productions, and this is going to reduce cost in the matter. They're an effective way to limit the scope of discovery, of determining, what isn't going to be collected, what's not reasonably accessible, what need not be produced. And on the flip side of it, it's an effective way to specifically require production of specific ESI needed to prosecute or defend one's case. What is the form of the protocol? Mentioned before, this can be an order and agreement, and there'll be overlap with a case management order, and many of the matters that could be in this protocol could be in an expanded case management order, and you could have certain case management matters covered here or explored in more detail here. There's also relation to protective orders, in that parties will generally have protective orders in most complex litigation, and some of the matters can overlap with matters that are in this type of protocol. And I mentioned before that there's increasingly seeing standing protocols in different courts, and often it's by case type, but sometimes just some certain jurisdictions are offering or requiring it now. What are the legal requirements? Well, there's not a lot there that's required, subject to standing orders and form protocols and what's required for case management. There's not really legal requirements per se for having an ESI protocol in most states. Where they come out in the federal rules is under the meet and confer requirements. And as everyone knows, the requirement to meet and confer following 21 days before the scheduling conference, or when a scheduling order is due under Federal Civil Procedure 26. And at the meet and confer, it covers the same matters that we have in the protocol here, such as preservation, form of production, just develop a discovery plan. And there's not a specific requirement that this turn into an order, but it certainly can and should in most matters. And we'll turn in the webinar now just to go into some of the specific negotiation points that will be that can be included in that, and talk about why you might want to have these. These ESI orders can specify preservation activities and not leave that to doubt as part of discovery plan. And this can, narrowing the scope of preservation to areas where it's not required can significantly reduce time and cost in eDiscovery matters in a case. And it can be a combination of different things that would limit scope, such as subject matter limitation, time frame, carving out non-relevant or duplicative data sources that are not really going to be adding a lot of additional information to the case, and then identifying and excluding data sources that are not reasonably accessible. Holds are important to make sure that they've been done and they're understood by the parties. So the ESI protocol can address when holds were issued and to whom, and what the procedures were for auditing that. And there can be a number of other preservation issues regarding time-sensitive sources, metadata, changes in employees, document deletion, and preservation policies. It can cover collection methodologies. It can specify acceptable collection methodology. The recent amendments a couple years ago to the Federal Civil Procedure changed what had been the long-standing rule of requiring production and thereby collection, of course, of information that's reasonably calculated to lead to discoverable information. That was deleted, and instead the rule focuses on proportionality of the information, and that can roll back to what's being collected as well. There are different ways of collecting information, and these can be specified in the case. The forensic image of custodian drives is the gold standard, and this is the safest approach, but it can be overkill in many matters or with particular custodians, and it also doesn't cover a number of other things like shared network drive and cloud drives, accounts, etc. A directed collection of drives can be more cost effective, and there's a number of protocols and different technologies and devices for doing that. And then there's a question of who collects that. It could be company IT people versus outside eDiscovery vendors, eDiscovery experts versus the individual custodians, depending on the circumstances with different pluses, minuses, and risks. At the end of the day, it's the attorney in the matter who's responsible to the court that the collection was done properly under the certification requirements. One negotiating point for ESI protocols, and this can also be in the case management order, is who are the custodians, how many custodians, and who are they? A custodian, of course, is a person who has possession or control of discoverable ESI. The ESI agreement protocols or the case management order can tie down who those custodians are. And then there needs to be a procedure for determining what ESI repositories the custodian has, and this can include drives, databases, other data sources. And there are major evidentiary quality, quantity, and cost implications of who the custodians are, what are the data sources being properly identified, and how are they collected and reviewed. Next matter that can be covered is culling and deduplication. This is most important when there's been a broad collection, as in imaging collection drives, custodian drives, or everything's been collected for a custodian, as opposed to keyword searches being used at the time of collection. But if there's, often in any case, and particularly if there's been a broad collection, there needs to be culling and deduplication. The culling is defensible data reduction that removes data from the review set that is unlikely to be we'd be responsive information. Number of ways to do that. Certainly date limitations of the data that was collected when it was produced or when it was created or last modified. The file types, certain unusual file types may not be important at all and can be excluded, and other file types may be critically important in a case type, and then make sure they are being collected. It's possible to identify what we call exact duplicates of information in the case based on a hashing technology that ensures that they're exact duplicates of each other. And this can be done with loose files based on a pretty straightforward process. And then emails, it's a little bit more complicated because it's done from construction of the metadata fields to from date, time, subject line. Horizontal deduplication removes duplicates across all of the custodians in a matter, and vertical deduplication removes duplicate emails only within a custodian collection. And if vertical dedupe is done, then there needs to be some sort of log that associates the emails that were removed of custodians, so that one has an ability to get back to determine which custodians had access to it, even if it's been deduped for a particular custodian. When determining what custodian information should be collected and been prepared in the matter, the ESI orders or case management order can sometimes have an initial data exchange of what custodians are likely to have discoverable information, non-custodial data sources such as shared network drives or shared electronic workspaces, whether on networks or in the cloud, databases that might have relevant information, document retention policies and procedures, summaries or whether or copies of them, whether they were halted at the time of a trigger from a hold, and then identifying what the parties believe would be not reasonably accessible ESI. This can also identify the custodian collection procedures for individual custodians. This overlaps with what should also be in the request for production of documents as well. But typically this would cover email, work and personal to the extent personal is used with the work at all, computer, workstation laptops, tablet computers, smartphones, mobile phones, cloud-based accounts, chat and messaging applications, which are becoming increasingly important, custodian contacts possibly, and issues on collecting these work versus personal, what the time frame is, and if any of these have been lost or destroyed by the custodian, that this is identified early on and determined what additional steps might be taken to collect any non-duplicative information. And there often is a lot of duplication between these different data sources today, so this comes into whether it's proportional to go to any particular data repository which might be collected elsewhere. The rule on not reasonably accessible data is Federal Rules 26. It says the parties are not obligated to produce ESI that's not reasonably accessible. This is presumed non-proportional, but perhaps not in a particular situation, as it depends on particular case circumstances. The most accessible would be active online data such as email accounts, hard drives, portable devices, cloud storage. Less accessible would be backup tapes, arrest fragmented or damaged data, system files, Slack materials off of hard drives, etc. And the agreement of the court might provide that not reasonably accessible information needs to be collected and produced, but there may be cost shifting or cost sharing in this circumstance. To be able to do this properly, we recommend doing a data mapping log, and we have a tool that we've prepared in Excel that is available for clients. And then what it basically does is identifies who the custodians are, you can see on this spreadsheet, and then specifically identifies all of the individual data sources or data repositories that a custodian has. So this can include the laptops, phones, text messages, different cloud accounts. I mean, it wouldn't be unusual sometimes for a custodian to might have 10 or more different repositories. It can be determined if these are reasonably accessible or not, and how large they are. And getting a data map like this does a couple things. One is it allows you to get your arms around how much information custodians have and find out about it earlier rather than later. It gives you accurate information on how to collect it and where it needs to be collected from. And it also helps in your negotiation on which custodians and which data sources. Also, it helps protect you against an allegation that you undercollected later or allowed information to be deleted, to show that you had a good faith effort to find all the information out there in a reasonable manner and that you had reasonable procedures. These lead to reports, so you can determine how much information is available by custodian or data source. We recommend doing this for your own custodians, of course, and having this as part of the procedure of when you do identification and collection and part of your early case assessment and planning. I think it's also a good idea to do this for opposition as well. You can ask questions to be able to put this together yourself, and this helps determine that you make sure that you're asking for all the information that is on the other side, and that there hasn't been an under collection because of ignorance of what data sources custodians have. And of course, you want to find out about this earlier rather than later in your case. Next in the protocol, often there's a description of the processing selects and how that's been handled in processing. And this can cover a number of things that are standard, but can be done differently from collection to collection. And it's a good idea to understand what these are and how material it is in your matter, and to make sure that's been done competently. There's a process called denisting that deletes files that are part of usually software installations and are usually going to be non-relevant in a matter unless it has to do with that particular software. And there are collections of these, and the processing software will run against that and delete those out of the system. Deduplication we talked about before, determining whether it's being done, and if so, vertically and horizontally, and how the logs are done. Time zone used when going into processing software, it's necessary to identify a processing time zone for custodians to make sure that the emails match up between custodians. The two ways it's generally done is either the custodian's usual time zone is used, and this does a generally good job of getting all the emails into sync for review on when things were sent and received between persons. That can be a complication when custodians are traveling between time zones, and it's not a usual practice to try to track that down on a email by email basis, and that's not really really doable, because at the end of the day, you don't know, did they send that email out right away, or did its Outlook sync up after they got to their next hotel room in another time zone? So nobody tries to run it down that far. So this will get it pretty close, but particularly with moving custodians, not 100%. The way to get this to 100%, if that's important in the case, is to use universal time or Greenwich Mean Time instead. That has the advantage of putting everybody on the same time zone, but then having that to be a time zone that's not particularly relevant to anybody, unless you live in central England. Another matter is email threading being done, and then how's that being provided? And then also what metadata fields are being preserved, and they're going to be produced later with the load files that we'll talk about later. And there's a graphic there showing some of the metadata fields for different data types and how they're preserved. Next, we'll talk about review procedures. No one hardly does linear review anymore of all the documents on larger cases. So usually a lot has been identified with keyword searches, and how are keyword searches being done there, and the options there can be no mention of how keyword searches are being done, or the parties are going to agree on them in the ESI order, or there can be agreed keywords that could be set out, or there could be a procedure to set them out. And you can also cover testing procedures of looking at keywords and determining if there's a false and what the rate of false positive and false negatives would be in a matter, and if that's important to the parties, and if there's going to be an outside review with a managed review, that can sometimes also be addressed, what the procedures are there. And then another way of determining responsive documents can be using predictive coding or technology-assisted review, and the procedures for that can be set forth in the ESI protocol, and these can be fairly short descriptions of how it's been used, or sometimes they can be very elaborate depending on the needs of the parties. And they can, the protocols in little or a lot of detail might cover what the TAR algorithm used is, what the seed set size and contents are, how seed sets are chosen, the control set size, the F score, or scores, which is precision and recall, how those are determined, and what those are, and what the report looks like. And here's an example of the Lexby report on that. I think an important matter on this is determining the transparency and being comfortable with the algorithm and how it was used. Some algorithms have a high degree of transparency, based on commonly accepted predictive coding protocols. Other ones are a bit more of a black box approach, and they may not be fully disclosed as to how what the algorithm was, or what the selects were. And if one is using or receiving it, you would the more that's a black box, you would want to understand the algorithm used and then what the selects were on it, to make sure that responsive documents are being identified and used in a manner that's best practices and acceptable to the parties. Related to all this is the form of production requirements under Federal Civil Procedure 34. I wanted to just briefly refer back to those rules, as some people get into trouble with this. If there's no agreement between the parties, the ESI is to be provided in the form that was ordinarily maintained, or form that is reasonably usable. What does that mean? Some litigation on that. That certainly is the native format that they were maintained in, and then some litigation of whether that could mean paginated view, PDF, or TIV absent agreements of the parties. And I think the courts generally have said no, that the form the ordinarily maintained usually means native, but there's different cases on that. If there's a specific, if the requesting party specifies a different form, and the receiving party does not object, then the receiving party is bound by the requested form of production. So this is where somebody could ask for a TIFF load file or a PDF load file, and even if that wouldn't have been required in the absence of a specific request, if the requesting party asks for it and there's no objection, then the receiving party is bound by it. So the receiving party, they receive a request like this, need to make sure that they're happy with what's in the request for production, that they can respond to that, because the courts are not likely to let somebody out of not responding to the request for production in a timely manner, although people try. If there's a specific request and then the receiving party objects, then the producing party can object and propose its own form. This is a confusing set of rules on how this works, and this can be bypassed with a good ESI protocol that just specifies the different delivery formats. And that's the meat of many ESI agreements, orders, and protocols. Another matter to consider with this is what review software is being used. So when one is negotiating an ESI order or protocol, or propounding a request for production or receiving them, it's important to know at that time what document review technology software is going to be used, because that's going to drive what form of production one can deliver to the other side and wants to receive. lot of the major ones are standard and can handle almost everything, but people get themselves into trouble if they're using something non-standard, or there was a non-standard request that they have a difficulty working with in their software technology, and they didn't know about it early on in the process, or agreed to an order, or didn't object early enough to a request for production. And then the different software can be used. The eDiscovery document review applications, Lexby and others are designed to organize search code and produce large data sets. And they generally work with different types, although some systems are specific to some types of data coming in, and they can only produce certain types of data. Small data sets, they certainly can be done in an eDiscovery application, and we think it's a good idea. But sometimes firms, for something that's very small, will work in a document management system, or Adobe Acrobat sometimes, or even Outlook directly. This next slide shows a little bit of what's included in a standard load file that's used for productions commonly in the industry. And I've got a couple slides on that. It will include the files in different folders within a production, and these productions can be in general, or sometimes they'll be done by custodians. They'll include images, which will be TIFF versions of files, which is a single page image. They'll include the load files, which allow metadata and document associations and page associations to be read up into the eDiscovery litigation database to tie together and make associations between the files. The native versions, if those are being produced, can be included. Sometimes there'll be PDF versions of files, and unlike the TIFFs, they'll be joined into PDFs. And then there can be text extraction that again is read into the databases. The load files, allow the communication, as I mentioned, between pages and documents, and have the metadata. If you haven't ever looked at one of these, they're not very friendly to the eye. So this is one out of a common DAT format that's used, and you can see with the highlighted words how some of the information from the email has made it into the load file. But these are difficult to look at directly, and certainly shouldn't be edited or anything. And they're usually produced by computers for computers. This is another version that's done, so DII format. That's a little bit more structured, but it's the same information. And then last version, we convert these into an Excel format of these as well, in addition to the DAT and the DII file. That makes it a little bit easier if one needs to pull one up and look at what was actually received before loading it up into a file, but it's all the same information in the last three slides. And the information that's included in the load file includes all the fields that will include metadata and other collected data that's important for proper usage in the eDiscovery system. And this shows the number of fields that are being collected, and these are part of the protocol, and these are what are produced along with the productions that go out and are part of the load file. Next, I want to talk about databases. I think databases are becoming increasingly important, or even critical, in modern commercial litigation, and oftentimes these are overlooked because the parties may not fully understand what ESI information was used and what might have been the importance of the organization. These would be identified early on in that data mapping process that we talked about earlier, and they can certainly can and should be identified and then covered in an ESI protocol for how they're going to be collected. And they raise some additional issues beyond more standard types of ESI. The types of databases that we can see that are important often are accounting ones, such as QuickBooks or other accounting systems. The CRM, which is customer relationship management software, very, very popular. Salesforce and other similar software systems, and these can be heavily used and relied on by companies. And then there can be separate operational or custom designed databases or that are used within industries or within a particular company, and where these are used often. That's very important information there. These may be highly evidentiary depending on the subject matter of the case. Sometimes they're highly proprietary as well, and one would want to know what fields and are in the database and what were commonly used queries and reports. Important to know who maintained the databases and how they were used internally by different custodians. When they're produced, it's rare to produce an entire database and not really that useful. So the better practice usually is to jump in and determine what reports or what fields are required, and then have the reports run, queries recreated, and often the information is often exported out into Excel spreadsheets, which can be done out of databases. And that's what actually gets produced. But did want to determine how this was being done in the ESI order. Here's a map just out of Salesforce of showing all the different fields and what are the relationships between them. So we've got leads, accounts, contacts, quotes, opportunities, products, and this is just really out of the box with the Salesforce. And then these can be highly modified by parties or consultants. So if you know that a litigant is using these, you'd want to jump into it and determine the specifics of it. Another issue I want to talk about is native production. Native refers to, as I mentioned before, of producing the original versions of the document. So this could be the Word Excel versions, AutoCAD files, some similar documents. This can be a highly contentious area, and opinions vary on when, if ever, these should be produced. And it can certainly be a difference between the parties on whether they want to have these produced based on their relative positions in the litigation. The options generally are, normally there's a paginated version of the native documents as well, and that's done for a variety of, for several reasons. One is to make sure that you can bait stamp. It's usually not a usual practice today to go in and bait stamp a native document because that changes the metadata and isn't as usable. So there'll be a paginated version, either a PDF or a TIFF or both, that has the bait stamps and confidentiality and labels required by protection orders or identifying as AEO information. And then all the natives can be produced as well sometimes, or sometimes only the Excels and PowerPoints or other specified data types, and that's because Excels traditionally don't turn into paginated versions of documents very well and can be really just spaghetti. PowerPoints, when PDFs or TIFFs are being created on a paginated basis, depending on what the print settings are, oftentimes speaker notes or changes of documents, may not make it into that paginated version. Although it's possible too, we have in the Lexby system, we have what we call an Uber index that pulls information both from the native on a text extraction and from an OCR version from a PDF that we create. So we are able to pull that information into the search index, but many systems won't do that. So you may want to have those file types produced to make sure that you're getting them. And then a third option is no native at all unless good cause is shown for using producing the natives. In any of these cases, if somebody shows additional or good cause, that oftentimes the natives will need to be produced. And then usually the container files are not produced if they've been expanded, even if natives are being produced. And as we'll talk about a little bit more, that if one has redacted a paginated version, a TIFF or a PDF, it's important that the native version or the container file, including the native version, also be withheld from the production to make sure that you haven't given up the redacted, or same thing for privileged information as part of the productions. Increasingly, there is use of native redaction tools that I'll talk a little bit more later. And there's an increasing responsibility as privacy laws and initiative have increased to make sure that there's been proper redaction of PII within a case. Redaction can also be specified under as confidential information under protective orders. There's a relation on this to AEO, attorney's eyes only information. So sometimes highly confidential information may be shown only to the opposing attorneys, not to the parties or others, or only to an expert. And to the extent that isn't done, that it may be redacted. So this will generally be covered in the protective order. It's a common practice and a good practice to use redaction to remove privilege and then have a supplement to the privilege log for redacted documents. And this allows email bodies and families to be produced together, where otherwise they need to be split up. One thing that comes up is whether or not redaction is permitted for relevance or non-relevant documents. So we see this come up occasionally. I'm not aware that ever is allowed, other than by agreement of the parties. And the idea there would be to redact information that's not non-relevant. If anyone is aware of this, I appreciate letting me know, because it comes up occasionally, and I've just never run into case law where that's permitted. Onto the redaction procedures. Normally, most eDiscovery platforms will have an inline tool for removing the redacted information, and then the redacted version is produced, and the native version is withheld. And then for PDFs or TIFFs where this has been done, there's a need to re-OCR. Some mistakes in the past have been made, famous mistakes with people trying to redact PDFs and not understanding the complex nature of PDFs, and they won't use a proper redaction tool, such as an eDiscovery tool designed for that, or Adobe Acrobat Pro, and they'll go in and use just drawing tools, and they won't actually strip out the underlying text layers and disclose information for anybody that knows how to look at it. So it's important when redacting PDFs to make sure they're using a proper tool and you're using the redaction portion of the tool rather than the drawing portion of the tool. What are tools to use for that? Lexby and other eDiscovery platforms will usually have inline redaction tools to allow you to redact your documents. Adobe Acrobat Pro, it has a lot of tools, and they spend a lot of time on that. So it's possible to use that and pull your redacted document down offline and use Adobe Acrobat, and it's got a lot of great features, including text search. And then you can import your redacted documents back into the eDiscovery platform and replace the redacted versions in the document record, so that the logic of the production will use the proper redaction version. And then increasingly, there's some native redaction tools out there, primarily for Excel, for people going in and redacting Excels natively as they don't paginate very well. Next, I want to talk a little bit about privileged information. This often is covered in the eDiscovery protocols, and it can rationalize and define and narrow the privilege logging requirements if agreed to by the parties. Include schedule the log delivery, limiting dates of logging, allowing it by thread, having categorical logs, and we talk about that more in another webinar we have on privilege. And these privilege logs often can be very, very large in document-intensive cases, and they're automatically created for review out of the eDiscovery document management software with the metadata provided by the documents. Here's an example of what that looks like. So you have the receiver in the email, and then it's automatically extracted with the metadata extraction into the coding fields of the review platform, and then it makes it into the privilege log here eventually as well. Clawback agreements are specifically allowed under the Federal Civil Procedure, and they're commonly used in ESI protocols and other court documents in cases involving a substantial amount of ESI. And it provides that inadvertent disclosure of privileged information doesn't operate as a waiver. It's not a panacea, as the disclosed information might be independently developed elsewhere, but I'm not sure there's really ever a good reason not to have a clawback agreement in any case where you've got a substantial amount of privileged information being produced for protection. And lastly, I wanted to address having an eDiscovery liaison that's often appointed as part of the eDiscovery agreement. So you have a technical person that will allow for communication between the parties on anything that needs to be worked out of a technical nature regarding ESI. This might be the same person who was involved in the Rule 26 as a technical expert for the parties. The courts like seeing the eDiscovery liaisons, and this can be a eDiscovery or technical consultant or forensic consultant, serve as a point communication between the parties over eDiscovery matters. And that completes all the substantive matters that are wanted to cover in an eDiscovery order. As I mentioned, we've got a model order at our website that covers all this and has the legal language, includes alternate provisions for some of the matters where that's important. And a link to this will be included in the webinar. A link following the webinar, we'll send out an email to everybody, and it's available on the on-demand version as well of the webinar. And if otherwise anybody wants a copy of that, it's available at the website, or ask any LexB staff member for it. So that will complete everything. Sorry, this ran a little bit longer than usual. And again, please stay around for a couple more minutes and let us know what you'd like to see. Thank you. Bye-bye.
Thanks, Gene. That was a fascinating presentation. I'm going to talk a little bit about LexB before we wrap things up. LexB is uniquely positioned to help boutique law firms and organizations that want to keep eDiscovery in-house and solve for the challenges of the shifting ESI landscape. We equip boutique firms with the most efficient infrastructure, expertise, and advanced capabilities. LexB really facilitates the mantra of lean and mean for the boutique firm with on-demand, cloud-based eDiscovery. You also have leading-edge technology and performance, as well as security. And it's all a fraction of the cost of eDiscovery platforms like Relativity. LexB auto-scales to ensure we get you from ingestion to review faster than anybody else. And the LexB eDiscovery platform can easily be accessed by virtually any internet-capable device, including PCs, Macs, iPhones, iPads, and Android devices. Although I probably would not recommend doing a document-intensive review on an iPhone. That would be a bit challenging with the screen size. Next, LexB equips you with state-of-the-art technology that is very simple to use, so you don't have to have dedicated IT support or litigation support professionals on staff in order to have advanced eDiscovery operations. Only LexB equips you with the Uber index. This is a highly advanced index that is comprised of native characters, OCR characters, and translated characters, all concatenated into a single index, so it operates much faster than multi-index environments. And then having native and OCR characters is very important when dealing with large document sets, because there are several use cases that require both in order to assemble a complete searchable evidentiary set. And so you can find the evidence and privileged documents that you need. In addition to the Uber index, LexB also equips you with advanced technologies to assist you in the document review. The LexB eDiscovery platform includes advanced email threading visualization, near-dupe groupings, which I find particularly powerful, especially when dialogues cross communication modalities, and then technology-assisted review for very large document sets and getting your review done in a timely fashion. We're also leading the industry in the use of artificial intelligence to assist you in efficient and precise document review. With LexB, you'll have highly advanced but simple to use AI-powered solutions like cognitive image recognition. So this helps you quickly find the images that are relevant to your matter the artificial intelligence algorithm analyzes all the images and is able to categorize those based on the content of those images. We also have a neural network powered language translation that delivers amazing fluency for machine translation and enables you to maintain control of the matter and not have to outsource that. And that also saves quite a bit versus human translation. And then we've got advanced AI-powered video and audio file transcription. This helps you to quickly identify timestamped audio segments that are relevant to your matter and helps you get through those types of files. Here you'll see Lexibee's email thread visualization capability has great utility in that you can zoom in or out of large email threads, you can select emails and view the metadata, and you can quickly identify where there are missing emails that could have been excluded from a collection or production. Lexibee also enables you to quickly compare emails side by side, and it's color coded so you can see what the differences are between emails. Lexibee also provides the support and professional services in the event that you need them. Therefore, you don't have to have a large litigation support department or IT staff to operate eDiscovery in-house. Lastly, I'll let you know that Lexibee is the most affordable, full-featured DIY eDiscovery platform. We don't charge processing fees, and as an example, this saved one of our clients over $31,000 that a Relativity reseller was going to charge them prior to document review commencing. We don't charge user fees, we don't charge case fees, we don't charge a setup fee, and you can get started for as little as $5 per gig per month for a subscription. Or if you don't think your matter will last long, you can get a month-to-month plan for $15 per gig per month. And with that, I'll ask our last polling question, and that is, would you like a demonstration of the Lexibee eDiscovery platform? While you're answering that, I'll thank you for attending today's session. We'll be making the following available to webinar attendees. You can get a recorded streaming version, an MP3 podcast, or PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. You will see a survey at the end of today's event, and we take your input very seriously. We definitely want to continue to improve the content that we bring to you in these sessions, and so we would greatly appreciate if you filled that out. For future notices of live and on-demand webinars as part of this series, please email us at webinars@lexibee.com or follow us on LinkedIn. And with that, please watch your inbox for an invite to our next webinar on best practices in eDiscovery. And thank you for attending, and thanks, Gene, for the great presentation. Take care, everybody.